Yes, counsel. Good morning.
Good morning, Mr. Chief Justice, and may it please the Court. One of the essential tasks of any trial judge, particularly in a criminal case, is to screen contested exhibits to determine whether they are relevant, and if so, whether their probative value is substantially outweighed by the danger of unfair prejudice to the accused before allowing them to be admitted into evidence and displayed to the jury. That, of course, requires a balancing test, which is normally consigned to the sound discretion of the trial judge. In this case, however, that essential process failed when the trial judge allowed the Commonwealth to display and exploit a set of graphic, inflammatory, highly offensive materials, including a really repugnant, offensive video, which the trial judge did not even bother to view before admitting into evidence.
Could I just ask you, Mr. Sultan, are you saying none of it, or there was too much and the video is in a special category? I understand that. But are you saying none of this should have been admitted?
Yes, Your Honor. I'm saying that as a body of material, that this material, the probative value was slim to none on the one hand, and the prejudicial value was so high that, yes, none of it should have been admitted.
The judge knew that the defense was this was consensual acts.
Well, he had been told that that was the defense. That's correct. But with respect to the probative value of the material taken as a whole, if I can first address that, I mean, this was obviously a case where the defendant was charged with attempted murder and related offenses by strangulation. These were materials found on a computer in his home that related to strangulation. That was the connection. And number one, there was no testimony by any Commonwealth evidence as to when any of these materials had been accessed by the defendant, let alone if they had ever been accessed by the defendant. Putting aside the complete lack of any temporal connection, which contrasts sharply with cases in which this Court has allowed in graphic materials, a case like O'Brien, for example, where the Court said there was a 1-month gap between the article was 1 month before the killing. Putting aside the lack of a temporal connection here, it is problematic, I submit, to utilize materials which constitutionally protected materials which a person possesses or reads or views as a way to infer that individual's intent and state of mind. That is an extremely problematic road to go down, as many courts have recognized. Is a person more likely to have committed child rape because he possesses a copy of Lolita? Is a person...
But that argument, I mean, by that argument, you would never allow any of materials found in somebody's...
Well, Your Honor,
right?
Of course, it is like anything else. It's a balancing. And so you're balancing the probative value. The mere fact that these are materials about strangulation, and this is a case about strangulation, that's not enough. You have to ask more questions.
But it's not just about strangulation, right? I mean, it's about strangulation in a sexual context.
Yes, Your Honor. And that is a closer connection. You have to ask, is there a temporal connection? You have to ask, is it a modus operandi? You have to. These are questions that relate to how probative the material is. This is a very fact-specific determination. Of course, I'm not saying it never could be introduced.
But the crime here is one that involves asphyxiation as an adjunct to sexual activity. And that is precisely what all of these materials relate to. That's
true, and that would be a mark in favor of it having greater probative value in doing the balancing.
And you have a defense that, well, I think maybe this is what Justice Lang is saying, but it's different than if there were, you know, either the defense was we're going to show that the Commonwealth hasn't proved it beyond a reasonable doubt or whatever. But if the defense is, yes, this happened, but it was in this other context, why isn't that very probative of what the defendant's intent was?
If in fact, if the defense is this was part of a sexual activity, the fact that there's stuff on the computer showing strangulation as part of a sexual activity, essentially it's almost conceded. There's no reason.
But
it's not a case, for example, where the defendant said it was an accident and you've got this stuff on the computer which would impeach that argument. But obviously probative value is one half of the equation. but the lack of a temporal nexus is significant here.
The other piece, besides what we were just talking about, is the further piece, and that is not just the asphyxiation, but as a motive or modus, that asphyxiation leading perhaps to death or near death.
Well, that was
Not
part
just strangling to a point, beyond a point.
Well, that's correct, Your Honor, and that is what the Commonwealth argued, that we have to improve, we have to prove intent to
Right.
kill. And the fact
Right.
that these videos and other materials depict somebody dying.
So they were certainly relevant to the point. The issue is, was it overly prejudicial, given the point could have been
Well, I
made
think-
by arguing the
Well,
point?
I'm trying to argue
Right.
both sides of the equation,
Right.
but you have to look at the probative side. I don't
Right.
deny that there was
It is
probative
probative.
value. The lack of a temporal connection, I think, reduces it. On the other side, the side of prejudice, this stuff was overwhelmingly inflammatory. It was clearly going to create a powerful, visceral, emotional reaction in the jury. The fact is, even if this stuff could have, even if testimony could have come in, as this court allowed in Scott and Guy, testimony about what was found in the defendant's apartment, the probative value is the same. The computer expert could have testified, we found material on the computer which depicted women being strangled to death. That would have been far less prejudicial. The Commonwealth didn't want that. They wanted to show the pictures. They wanted to show the jury the video. There's no difference in probative value. The only difference is in shock value, to basically engender in the jury such antagonism and repugnance toward the defendant that they're going to convict him. It's the trial judge's job to carry out that balance and consider, among other things, cumulative effect, and consider ways of introducing something which is less prejudicial. If the Commonwealth has a right to get the evidence in by testimony, that's fine. But why do they have to show the video? There's no reason to show the video other than to unfairly prejudice the jury against the defendant, and that's what happened.
You say that the considerations are very different in connection with things like autopsy photographs and other crime scene photographs, and I appreciate that they are different in a certain respect because they relate directly to the crime that is at issue. But nonetheless, you can make exactly that argument, just have testimony about it. No need to have juries see this. It's unduly prejudicial. I mean, and the point, of course, is always that you want, the prosecution wants to put in something that's prejudicial. The question is it unduly prejudicial?
Is it unfairly prejudicial, I think is the question, Your Honor. And yes, of course, there were situations where, but judges do that all the time. Judges talk about redacting photographs, or do you need 20 photographs, or how about 2 photographs?
Well, 14 were allowed here and only 8 went in.
Well, that's true, but plus the video. And frankly, it is the video which takes this case way over the line. And it was incumbent upon, and when we turn to process, the balancing test that had to be performed, the judge, as Judge Granger put it in the appeals court, the trial judge was duty-bound to look at this video before deciding whether by itself or cumulatively it created unfair prejudice and had to be excluded. The exercise of discretion requires the trial judge to view the material. We're in a world now full of graphic material, and you cannot rely upon the description by an adversary counsel. It's the trial judge's job to see it. It's self-evident that that's
now,
the case.
Judge Granger said that the failure to see it was itself an abuse of discretion, but I gather you're not going there.
Well, no, I am going there, Your Honor. It's an error of law. It is an abuse. That's
So
exactly
you're saying that by relying upon the descriptions of it, that itself is an abuse of discretion, and ball game's over. We don't need to see whether or not the balancing itself is.
No, I don't say the game's over. I say what that means is that he did not exercise discretion. He did not do that. Therefore, this court should not defer to his exercise of discretion. That's exactly what, by the way, I cited the court to 2 federal decisions, Laurie, a recent decision from the 7th Circuit, and Curtin, an in-bank decision from the 9th Circuit, where all 15 judges voted to reverse, where the same thing happened. And they said in both those cases the failure of the judge to actually view the material was itself an abuse of discretion, an error of law. So what has to happen here is not the ball game's over, we get a new trial. What should happen as a remedy, is that this court needs to view view that video and determine, as Your Honors need to determine, whether or not
That's a
balancing
substantial
probative
risk.
value and prejudicial effect, it's admissible. If it's inadmissible, then the court has to decide whether or not it's tainted the trial, poisoned the trial based on its exploitation by the prosecutor in opening, in cross-examination, and in closing argument to the point that the defendant requires a new trial. If the court finds independently that it's admissible based on its probative value, then the ballgame's over, I lose. But I submit that's what should happen. The trial judge should not be given any deference for exercising discretion when he didn't exercise discretion. But that's the point of the problem with the process that was employed here. The failure to look at it does not automatically entitle the defendant to a new trial. It rather entitles him
But then
to
there's
some
two more
court
steps.
looking at it.
And then you have to weigh if it shouldn't, then, as you say, then you have to weigh whether in the totality of circumstances it creates a substantial
Exactly,
risk.
Your Honor. And I would submit on that point that, the prosecutor mentioned this material, including the video, in her opening. She extensively cross-examined the defendant about these materials, and she repeatedly emphasized it in closing. Her point was this was his fantasy. This was his fantasy. He went over there, and that video, I submit it to the courts. It's a minute and a half long, and I asked the court to view it. Could not have helped but impact this trial in an overwhelming and unavoidable way. And that's why the defendant
Do you
is
know,
entitled
Mr.
to
Sultan,
relief.
I appreciate, and this, your argument was this is enough anyway, but did the jury have a machine to watch the video in the jury room as well?
I don't know the answer to that, Your Honor. I just don't. I don't. I'll
I
check
mean, they
the
obviously
record.
saw it in the courtroom. I just didn't know.
I didn't try the case. I'll check the record and I'll send a letter to the court if I can enlighten the court one way or the other about that. But they viewed it in the courtroom. I know that.
You remember the McGuire case involving the use of prior convictions, and the judge did not realize that he had discretion to keep those convictions out. My recollection was that because the judge did not realize that he had discretion, the defendant got a new trial.
That's right.
How does that play into your analysis in this case?
Well, I think, again, I think that I don't think it's fair for me to argue that the failure of the court to use the correct process is such structural error that it entitles the defendant to a new trial without a demonstration of prejudice. I think we have to show prejudice. If the video was admissible, there's no prejudice. So I concede that, but I think that an independent viewing of the video will indicate that it was not admissible and that it did poison the trial to the extent that a new trial is required.
Now, is there any evidence as to the temporal matter, as to how old the computer was, or as to is there any evidence that can say this was copied by him no later than?
Your Honor, there was no evidence at all put on by the Commonwealth on that subject. The only evidence on that subject was that when the defendant testified, he testified that he had belonged to some website that these materials came from 10 years ago or so, and that he had last viewed them a number of years ago. That was the only evidence at trial, to my recollection, on that subject. The Commonwealth did not put in the computer person, Sergeant Neff, testified he had not attempted to determine when they had last been accessed.
So was there any evidence about how much of this kind of these kinds of photos or this kind of material was on there?
I believe Sergeant Neff testified, I forget the number, maybe that there were 2,500 references and 500 photographs or something in that neighborhood. It's in Sergeant Neff's testimony. But he testified to a much larger volume of materials on the subject of asphyxiation. But this was the only video that was shown.
With regard to the Google search inquiries, any sense of when those were done? There were many Google search inquiries.
I don't think there was any testimony on that subject, Your Honor.
Now, as to the video, I seem to recall that the defendant testified that he knew the woman who was depicted in the video, making it seem like that what was shown, which was apparently the woman's life being snuffed out by being asphyxiated, turning different colors and so forth, was in fact, she lived to do this sort of thing again. This was not
Sort of a demonstration.
reality. This was not reality video, but
That was his testimony, but certainly it wasn't. That was not conceded by the Commonwealth in closing. The Commonwealth basically said, we don't know whether or not this really happened. So that is what the defendant said, but I think the video speaks for itself, and it's pretty outrageous. If I just may say, there is a second issue which the court need not and may not choose to reach, which has to do with the constitutionality of my argument was that the defendant was entitled to a defense of consent in this case, and that this court, in the wake of Lawrence, should overrule Appleby and find that you no longer can make it that if consent can be a defense to A and B on the sports field, then it also must be a defense to consensual A and B in the bedroom. And that's my constitutional argument, but I see my time is up. Thank you, Your Honors.
Good morning. May it please the Court. Kenneth Steinfield for the Commonwealth. I'd like to begin by answering Justice Botsford's question about whether or not the jury had the 90-second video clip. They did not. They were told that they could have it if they wanted it, that if they made a request. And this is just before the jury sent them to deliberate. He told them, you will have all the exhibits, but if you want to watch the video, we will have somebody sworn who can come into the jury room and watch it. So we know the jury did not have the video in the room, and they never asked to see it.
thank you.
So just to make that clear. I'd like to start at the beginning and note that on the issue of the relevance of the materials, I'd start out by pointing out that Judge Welch carefully considered the relevance of the material and found that they were highly relevant, very relevant. And this court has repeatedly given deference to findings of relevance. And I think all the cases I cite, though as Justice Lang points out, they are largely in the context of autopsy photos and things like that of crime scenes. Here the same analysis applies because the photographs depicted exactly, also the video depicted exactly what the defendant was accused of doing. And as Justice Duffley pointed out, the key was that in all of the pictures, or most of the pictures and the video, it ends with the death of the person being strangled.
But doesn't the temporal element also go to the relevance analysis?
Yes, it does, but there was no objection whatsoever made on those grounds at trial. The defense counsel never said, look, Judge, we don't know when he accessed these or when he saw them. So that issue was not raised. But, and so there was no way for Judge Welch to know how recently he had viewed the materials. But defense counsel never stressed the point, never gave Judge Welch the opportunity to say, well, yeah, he might have been interested in this, 7 or 8 years ago. He testified that he had belonged to this website in the late 90s, and the crime occurred in June of 07, but that argument was simply never made.
So remind me, what was the defendant's argument on relevance? Forget prejudice for a moment. If it wasn't that there's no temporal connection here, what was his
argument? Was that just because you own things of this nature does not make you more likely to act them out, which the judge rejected and which this court has constantly rejected. That was the basis for his claim. Now, moving on to the second, and I do admit more difficult argument, is whether the judge's finding that there was no undue prejudice is proper in light, that the probative value was not substantially outweighed by any undue prejudice in light of the fact that he did not view the 90-second video. I do not believe, and I think that the appeals court, the majority opinion, properly found that in order for Judge Welch to exercise his discretion, he did not need to view the video. It would have been an ideal practice. Yes.
What do the cases say about this kind of audiovisual proffered evidence and this analysis? Is there, have other courts considered whether or not, as a general rule, judges are required to review them? I mean, it never really occurred to me, for example, with, written materials, that, a judge wouldn't read them before ruling on whether or not they're more prejudicial than probative. So you wouldn't just rely on somebody describing a document to you, would you?
Well, there is a case, a federal case that's in the brief, where there was a poor description given. There was an inadequate description given of some stories that a defendant had on his PDA, and the court held that the description was not sufficient because it didn't include all of this other stuff, which was inside the stories, which was far worse than anything that the defendant had been accused of. I have not found any case that's directly on point, but I think the closest is the Fredette case decided by the appeals court, where very similarly some information was brought to the judge's attention, specifically during jury deliberations, that a juror had seen the previous night an interview with the victim's mother, and didn't feel that it would sway him. And the judge there made no effort even to inquire or to find out what had happened, as he should have. He should have informed himself of what the nature of the interview was and whether it had tainted the jury or not. I think that's an analogous case that the dissenting justice relied on here, but I think this is a very different case because the judge did have before him the photographs, which I would admit 8 is a perfectly or a more than fair number given the amount of photographs that were found. There were more than 400 found on the computer, and I believe 978 hits or something like that, some number between 950 and 1,000. And though she had permission to introduce 14, she only introduced 8. So I think this shows great restraint on her part. But the key point is that I think the judge knew what was contained in the video. He got a description from the prosecutor that was complete and accurate and to which no objection was made. He had the photographs in front of him. And I don't think, and of course the court can look at both the photographs and the video.
Do we have the video now, or do we need to?
Well, the appeals court has it. They talked about, they have viewed it.
I'm not sure that they do.
Oh, well then I will certainly make a request to the clerk and to have it transferred immediately. I also would like the court to look at the color photographs, not just the black and white ones, because the color photographs are revolting, as I say, but no more than autopsy photos and no more than crime scene photos. And the video, I do not think, is any more revolting than any of the pictures. And the judge had in front of him 14 pictures that included a series of a woman being strangled during the progressive stages. So this is not the difference between somebody describing a picture and a video and the video itself, but it's the difference between still pictures and a moving picture. And I think it doesn't, as I said in the brief, take an extraordinary agility of mind for the trial judge to see what he has before him. He's got these photos, which are arguably revolting. They're disgusting, and they're hard for anybody to watch. But the video was not much worse, if it was worse at all. And also has been pointed out from the defendant's own testimony, we know that the woman in that video was an actress who lived. He said he knew her. Her name was Vicky.
Did the Commonwealth concede that point?
Well, the Commonwealth, the defendant testified to it. Mm-hmm. And the Commonwealth didn't specifically say you shouldn't believe him. The point that the prosecutor made was that in the photographs and the video, they end with the person being dead, or at least apparently dead. So it's the apparently dead that matters. She was saying, we don't know. She wasn't talking specifically about the video. She was talking about the pictures and the video when she said, we don't know whether these people actually died or not. The key is they appear to have died. So I think she certainly would have said, you heard, had it occurred to her, or should there have been a need for it, you heard the defendant say that she was not dead.
So in this case, there was no objection to the admission of the video.
Well, there was objection. Yes, there was,
There
but
was an
not
objection.
on the. Yes, but it was solely a probative value versus undue prejudice argument.
Was there a special objection to the video, or was it sort of one objection to all of the photos
One
and the
objection
video?
to all. They joined. Well, no. Let me back up. They brought up the whole ball of wax, the video and the photographs. The judge said, "Well, let's focus on the photographs first," and he viewed the photographs, and then he said, "And I understand there's also a video." And the prosecutor described the video perfectly. And then the judge, when he made his ruling and said, "I find that these are of great probative value and that they do not substantially outweigh any undue prejudice," there had been a discussion of both the photographs and the video. So when he made that ruling, he clearly had them both in mind.
And trial counsel didn't say the prosecutor's description of the video is not correct.
He didn't say a single word. He didn't say, "Judge, I want you to view the video." He didn't say, "Judge, you have to view the video." He didn't say...
What if he did say that?
Well, then, as I say, it would have been a very, very simple task for the judge to have said, "Okay, we'll take 2 minutes, have somebody set it up, and I'll watch it." Like in the...
And if the judge doesn't do that, in the face of a specific objection that he must watch it, how do we review that?
Well,
Do we do the same thing we do here? We just look at the video and decide if it was prejudicial, and then we apply the prejudicial error standard as opposed to perhaps the substantial risk of a miscarriage of justice.
Right, but I don't think that there's error to begin with. That the judge would have been permitted, as he did here, although I do admit, frankly, that it's not an ideal practice, and I'm not condoning it, and I don't think this court obviously should. But if a judge believes, as Judge Welch did here, that he had sufficient information to inform himself what was on the video, he should watch it, should the defendant ask him to watch it. But if he didn't watch it, although he'd been asked, I still think he would not have abused his discretion or made an error of law.
Is that the standard we should apply where a judge does not actually see the video, or should we do a de novo standard as the defense suggests?
Well, I think you have to defer to his finding that the undue prejudice, that the probative value was not outweighed by
But the theory of giving that deference is that the
Right.
trial judge is in a better position than we are, which of course the trial judge is with regard to being the person who's presiding over the trial. But we are now in a better position because we will have seen the video, which he has had only described. Does that mean we should still give the same deference involved in abuse of discretion?
I think so. I think that because he had enough before him when he made it, that was sufficient. I don't think the court needs to make its own sort of trial court-like determination. I'd also like to point out that when the video was shown in court, now the judge had no obligation to say, "Wait a minute, that's so different from the pictures that I'm going to review it," my prior determination. But he didn't say anything about it. He saw the video, and that didn't change his mind. And he gave 4 of what I think are the best cautionary instructions I've ever seen to the jury about how to deal with such evidence. But I think the fact that he did not commit error and he did not abuse his discretion.
Wouldn't it, at least in theory, really be we would need to give look at his decision not to see the video as whether that was an abuse of discretion. But it seems to me the video itself, how can you say that we have to defer to, since he didn't see it?
Well, because he had the full description of it, and he was able to extrapolate from the pictures that he had seen, which were of the identical nature, and I think in some ways worse than the video. I think the shock value of the photographs is worse than the video itself, especially in light of the defendant's testimony that everyone knows that the woman there did not die.
Now, in terms of the issue of prejudice, I guess what's
Yes.
a little bit is he basically says this is what he was seeking to do. He was
Yes.
seeking to asphyxiate her for sexual pleasure.
Right. Yeah.
And the video shows somebody, I gather, trying to asphyxiate somebody for sexual pleasure. So why is the video so prejudicial in view of his testimony?
I don't think that it's prejudicial at all in view of his testimony, that he candidly admitted that that he sexually desired or that was a fantasy of his, that he was involved, he said, in the whole asphyxiation scene or
The
something like
inference
that.
that the person died in the video?
Well, yeah, certainly one could draw the inference that the person had died. She turns blue and then she passes out. But it's all done in a certain way. A man comes out from behind a curtain and says, "Are you ready for your birthday present?" And she says, "Yes," and he strangles her. And she becomes blue and she dies, and then he leans over her and says, "Happy birthday." It's a disgusting video that nobody would want to see, that offends the sensibilities of most, but the defendant candidly admitted that he found that sexually appealing. So the fact that the jury had before them this evidence, I don't think there was prejudice because of it. And I certainly think that there was no prejudice because the jury would have had the photographs in front of them anyway. I think if the judge had seen the video and said, "Oh, wait a minute, this is just so awful because it's a moving picture that I'm going to exclude it," the jury would properly have had before it the photographs, which would have been enough, I think, to.
But don't we have to view them cumulatively?
Yes, yes, and the judge certainly did, both when he made the initial decision and when he saw the video during trial and did not seek to revise his earlier opinion that the probative value of all of the materials was not substantially outweighed by any undue prejudice. I see my time is up, and as to the claim that Johnson v. Texas overrules Appleby, I will submit on my brief.
Thanks.
Thanks.
Thank you. Let's proceed. Mr.